Welcome to IAS at Speed of Light, and this is the part 4 of Indian Polity Conceptual Lecture Series. Last time we have finished fundamental rights, which are there in part 3 of Indian Constitution, and now we are starting with part 4, which are directive principles of a state policy, and which are from article number 36 to 51. Now, to talk about the fundamental rights and the directive principle of state policy, actually they are of common origin. Once you will learn the modern history, there was a Nehru report in 1928. That particular report also contained many rights, like right to education for all. But when it came for the framing of the constitution by the Constituent Assembly, certain questions came up before them. The most important was which rights they have to declare as the fundamental rights, or whether which rights they have to make as justifiable rights, or which rights they have to make as the non-justifiable rights, and to what extent the state of India is capable to provide justification to those rights, justifiable rights. Okay, so it was almost agreed at that time that it was not the capability of the Indian state, because of the lack of resources, that a state cannot guarantee certain rights like right to work or right to education for all. So it is very clear that it was not the lack of will of the constituent framers, but it was the lack of the resources of the Indian state that time, that they could not guarantee certain rights to all of the citizens. There is one more very important report, the Sapru report of 1945, which divided these rights into two types, the justifiable rights and the non-justifiable rights. Now, justifiable rights, as the name suggests, they are enforceable by court of law, and these enforceable rights were included as the part 3 of the Indian Constitution, which we call as the fundamental rights. The non-justifiable rights, they incorporate certain directives to the government so that these directives can be implemented in the policies and laws which will be made by the state governments, and but without any guarantee. So they were incorporated in the constitution as part 4, and which we call as the directive principles of state policy. Now, directive principles, as the name suggests, these are the principles which helps in certain decisions of the government. These are the guidelines by the Constitution of India to the state to form their policies, to form welfare program as per the directives given in this part. Let us see certain important features of directive principle of state policy. First one borrowed this part from Irish Constitution, that is the Ireland Constitution, but it was actually not original Ireland Constitution, and Ireland Constitution also bought it from the Spanish Constitution. And there was one more source of directive principle state policy, and that is the instrument of instructions. Instrument of instructions in 1935 Government of India Act. So these instrument of instructions were there in 1935 Government of India Act to give certain directions to the executives, to the governors and the governor generals. So this act as the immediate source for the directive principle state policy in Indian Constitution. Second point is a fundamental in governance of the country. Though we have seen they are not enforceable by the court of law, but yes, these play very important role when the political parties go to the election. So these held ground during the court of the people. They are the instrument to the instructions that we have seen in 1935 Government of India Act. Their aim is to establish fair social and economic order, establishment of a welfare state, a socialist state, and not a military or a police state. Non-justifiable, we have seen, cannot be enforced by the court. Helps court to ascertain the constitutional validity of laws. Now, this is a point to understand. Now, suppose Parliament passed certain law, and it goes to judiciary for the validity. Now, this bill, it can be held void if it contravenes with any of the fundamental rights that we have seen under fundamental right, that bill will be held void if it abridges any of the fundamental right. But same doesn't hold true for directive principle state policy. The court cannot hold any bill or any law unconstitutional based on directive principle of state policy. But other way around, if we see, if they have to ascertain the constitutional validity of that law, they can use directive principle of state policy, and they can hold that law true based on if it is to implement certain directive principle of state policy. So it is very important declaring a law void and constitutional. They cannot declare the law void because of directive principle of state policy, but yes, they can hold the constitutional validity of that law based on directive principle of state policy. An important point to understand. Let's go to the articles now. Article number 36, page number 98 PM Bakshi. It gives a definition of the state. In this part, unless the context is otherwise requires, the state has the same meaning as in part 3. So we have seen article 12 of fundamental rights. So definition of state remains same. That is the parliament and the government of union, the state legislature and the state government and all the local bodies. So that becomes a definition of state for the purpose of directive principles as well. Article number 37, if we read, application of principles contained in this part. The provisions contained in this part shall not be enforceable by any court, a very important point to understand, but the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. So it gives us the information. First, directive principles state policies are not justifiable. Second, they are the fundamental to the governance of the country, and it should be the duty of the state to apply these principles while formulating or making laws for the governance of the nation. So important article to remember, article number 37, which says the directive principles of state policies are not enforceable or are not justifiable. Now, political scientists, they do three classification of directive principles state policies. As such, in constitution, if we see, there is no classification of socialist principles and other, but we study these principles based on these three different classifications. The first are the socialist principles, which give socialist ideas. Second are the liberal intellectual principles, and third one are the Gandhian principles. Let's move to the first classification, which is a socialist classification, and article number 38. It says the state to secure a social order for the promotion of the welfare of the people. Okay, so at first part it gives social system which will secure social, economic and political justice to all spheres of the life. Now if we see every term in directive principles state policy, it is directly reflected in the preamble of the country. So what state our constituent framers have envisaged in the preamble, those things we will find in directive principles state policy. So social, economic and political justice to all the spheres of the life. Second, if we read, and it is a interesting article, the state shall in particular strive to minimize the inequalities in income, and endeavor to eliminate inequalities in status, facilities and opportunities, not only amongst individuals. Now this is the important point, not only amongst individuals but also amongst the groups of people residing in different areas or engaged in different vocations. So here they are talking about the balanced regional development as well. So if it will be asked like which article has given balanced regional development, the point of balanced regional development under directive principles state policy, it is 38 part 2. Article number 39, if we give certain principles of policy to be followed by the state. The state shall in particular direct its policy towards the first, citizens man and woman equally have the right to an adequate means of livelihood. It is important to us also to analyze how government has strived hard to actually implement these directives into their policies and laws. Now, this particular 39 Part A, it is saying the man and woman should have equal right to educate means of livelihood, and to accompany that, to follow that Equal Remuneration Act 1976, which advocated for the equal pay for both men and women. Okay, so B, that the ownership and control of material resources of the community are so distributed at best to subserve the common good. So again, it's a socialist principle that the resources and the distribution of the resources should be in the hands of public for the public good, for the good of the poorer people as well. Part C says that the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment, again a socialist principle. There is equal pay for equal work for both men and women, the Equal Remuneration Act 1976, Narega. This also gives right for the remuneration for all, educate means of livelihood. E. That the health and the strength of the workers, men and women, and the tender age of the children are not abused, and the citizens are not forced by economic necessities to enter vocations unsuited to their age and strength. F, it says that children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity. Okay, so these are the socialist principle under article number 39. If you have seen article 31C, they have given 39B and C. So if government makes any particular law to implement these two articles, it cannot be held void for the contravention of the fundamental rights. Let's go to the next article, which is 39A, and which was added by the 42nd Constitution Amendment Act 1976, which is a very important article to remember, which provision in Constitution talks about equal justice and free legal aid. So free legal aid. So it is article number 39A, and to implement that, we have Legal Services Authorities Act 1987 and the formation of Lok Adalas, which give free legal aid and equal justice. Next article is article number 40, which will study on the Gandhian principles, the Gandhian's principle based on Gandhi philosophy. Second, now 41st is right to work, to education, and to public assistance in certain cases. So this article is talking about to secure right to work, education, and public assistance for the unemployed people, for the old age people, for the sick people, and for the disabled people. Now, to implement these directives, government has launched various national social assistance programs, okay, for the old age people, like Indira Gandhi old age pension schemes, Indira Gandhi widow pension schemes, Indira Gandhi national disability pension schemes, national family benefit schemes, and the programs like Annapurna, etc. So these all comes to implement this particular directive, which is given in article number 41. Article number 42, if we see, it talks about the provisions for just and humane condition for work and maternity relief, and for this we see Maternity Benefit Act 1961 being passed by the Parliament to enact this directive. Coming to article number 43, which is saying living wage, etc. for workers. So it is giving directive to the government to ensure adequate wages, good life, and rest to the laborers. Various socio-culture facilities to be made available to the laborers. Now, since from independence, we have seen a number of state-owned factories, industries, and corporations have been expanding, and more people have been given employment. Certain legislations like State Insurance Act, Employees State Insurance Act, Workmen Compensation Act, the Minimum Wages Act, and we have already seen Equal Remuneration Act in 1976. These have been implemented by the government to give adequate wages, good life, and rest to the laborers to ensure that this directive come in force. Article number 43. Coming to the article number 43A, which is giving directive to the government to promote the participation of workers in the management of the industries and the factories. Article 43B, which says the promotion of cooperative society. This has been added by very latest Amendment Act, that is 97 Constitutional Amendment Act 2011. So it becomes important which directive gives for the promotion of cooperative societies, and these things we have covered in the mnemonics as well. Coming to article number 46 now, which talks about the promotion of educational and economic interest. So educational and economic interest of SC, STs and other weaker sections of the societies and protect them from any exploitation. And we have seen so many acts and legislations have been passed by the parliament for the protection of the weaker section and to promote them through reservations and other things in good educational institutions. Second category or second classifications of directive principles, what we did was the liberal principles or liberal or intellectual principles. First one is article number 44, which tells the uniform civil code throughout the country. So this is a very, very important article and you have to remember it with its number. So what is the meaning of civil code? So Uniform Civil Code in India is the debate to replace the personal laws based on the scriptures or the customs of each major religious community in India with a common set governing every citizen. So they want Uniform Civil Code will be a single code of the personal laws for all the people, no matter whichever religion they belong to. So it will be Uniform Civil Code throughout the country. But this is not, it is debatable issue in India, and it can be a question in mains as well, like what are the challenges to implement a uniform civil code throughout the country. Okay, so and article number 44, and if any such question comes in means you have to refer to that particular article also, like which what is the constitutional position, what is the legislature position of that particular issue in India. Coming to the next article, which is Article 45, it talks about the early childhood care and education for all children below the age of 6 years. This thing we have seen in fundamental rights also, 86th Constitutional Amendment Act 2002, where this previously, this particular article, Article 45, which was having education for the children of 6 to 14 years. Now it is included in Right to Education, Article number 21A, and the matter has been changed here, and now it is talking about the early childhood care and education for the children below the age of 6 years. So this is also a very important Constitutional Amendment Act, 86th. Coming to article number 27, it gives us two informations. First, to raise the level of nutrition and health of the people, and second, it is saying the prohibition of intoxicate things. So second part, actually it's a Gandhian principle, the banning of alcoholic drinks and all. So this liberal principles will see the raise of the level of nutrition and health of the people under article number 47. Article 48, it is giving organizing and agriculture and animal husbandry on scientific lines. These things we have covered in mnemonics as well. 48A, protect and improve environment and safeguard forest. So again, anything related with environment and forest, other things, it becomes very important. So under directive principles of state policy, 48A, it deals with environment and forest. Okay. Article 49, which tells us about the protection of historical monuments and places of national importance. So many laws have been made, societies have been made by the government to protect these monuments and places of national importance. Article 50 talks about the separation of executives and judiciary. And the separation of executives and judiciaries for the public services. Okay. Article number 51, this particular article was asked in 2014 directly in prelims to promote international peace and security. They asked this particular international peace and security is in which part of Indian Constitution, fundamental right, directive principles of state policy. So it is under directive principles of state policy, article number 51. Important article to remember. So this is how questions are normally asked directly in prelims from Indian polity particularly. Coming to the third classification of directive principles of state policy, it is the Gandhian principles. Article number 40, which says the organization of village panchayats, and we have seen village panchayats have been made constitutional, the municipalities. Article number 43, it talked about the development of the cottage industries. 47, it talks about the ban or prohibition of the consumption of intoxicating drinks. Article number 48, this same article, when it is talking about the organizing agriculture and animal husbandry on scientific lines. It is also talking about the banning of slaughtering of cows and other milch cattle. So this is all Gandhian principles. Now there are certain directives which are outside this part 4 of Constitution as well, which we call as the directives outside directive principle state policy. One of them is Article number 335, a very interesting article which we'll study once we'll go to that, and it talks about the claims of scheduled castes and scheduled tribes to services. And it says that the claims of the members of the scheduled castes and scheduled tribes shall be taken into consideration, but looking also for the efficiencies in the administration. So claims of SC/ST, claims of SC/STs to services, but maintaining efficiency in the administration. And there has been one Constitution Amendment Act which was put by the Parliament to negate this efficiency word in this article that we will study. The second one, it is Article number 350A, which gives the instructions to the government to make facilities, to arrange facilities for the education in the mother tongue for the primary education. In primary education. Third one, it talks about the development of Hindi language, article number 351, Hindi language. So these are some of the directives which are outside the part 4 of Indian Constitution. Now let us see some of the differences between the fundamental rights and directive principles of state policy. So part 3 and 4, which are the chapters on fundamental rights and directive principles, they both are equally important. Fundamental rights are important and directive principles are also important for the overall development of the society. And they together therefore constitute the conscience of the Indian Constitution. But there are certain differences. The first difference is the fundamental rights constitute a negative conjunctions, which means they put negative restraints on the state for doing something, while the directives on the other hand are a set of positive directions from the Constitution, and this urge state to do something to transform India into a good welfare, social and economic democracy. The second difference is, very significant difference is, they are non-justifiable. Directives are non-justifiable and court do not enforce them. Fundamental rights, on the other hand, are justifiable and they impose legal obligation to the state as well as on individuals. Certain rights we have seen they are for the violation of from both state and the private individuals, and courts enforce these fundamental rights. Okay, so if a law violates a fundamental right, the law in question will be declared void. We have seen that if any law violates fundamental right, that will be declared void by the judiciary, but no law will be declared unconstitutional on the ground that it violates directive principles. Okay. This we have seen when we started the discussion on directive principles of state policy, the concept of declaring void and concept of declaring constitutional a particular law. So law cannot be declared void based on that it violates directive principles. And against the violation of fundamental right, constitutional remedy to constitutional fundamental rights, that is Article 32 we have seen, the right to move to Supreme Court. Right, and whereas if a directive is violated either by the state or the individual, this particular remedy, Article 32, it's not available. Now, another important thing to discuss under directive principles state policy, it is the conflict between the fundamental rights and directive principles state policy. Now, there has been conflict right from the date when the Constitution was adopted till now over the fundamental rights and directive principles state policies. Why this conflict is there are two basic reasons for this. The first one is the fundamental rights are the rights of the individual citizens which are guaranteed by the Constitution. And the directive principles lay down the various tenets of a welfare state. Now, the conflict arises when the state needs to implement a directive principle and it infringes or abridges the fundamental rights of the citizens. See, now the thing is, directive principles give certain principles for the state to implement for the welfare state. Now, what if, while implementing these principles, it violates certain of the fundamental rights? So, there comes a conflict between the fundamental rights and the directive principle of state policy. Now, second is the chapters of the on the fundamental rights and directive principles of state policy were added in order like directive principles are secondary to fundamental rights. Part 3 is fundamental rights, part 4 is directive principles of state policy. And the fundamental rights are justifiable and guaranteed by the constitution itself and they are enforced by the court. The directive principles are the directives to the state and government machineries, but they are not enforceable by the court. So what happens is if any violation of the fundamental rights on the ground that state is implementing directive principles, when it comes in front of court, then this dilemma for the court also comes up, like because fundamental rights no one can abridge. Okay, while directive principles are the state, the directives to the state that the state has to implement these directives for the welfare state. Now let us see the history of the conflict between the fundamental rights and directive principle of state policy. The first one is the Champakam Dorirajan case. And this is actually name of the lady from the presidency of Madras. Actually, this case was the first which came before Supreme Court regarding the conflict between the fundamental rights and directive principle of state policy. This particular lady, Champakam, she was denied admission into the medical college because that time one government order came which gave caste-based reservation. When this particular case came in to Supreme Court, that time even Lok Sabha was not formed. Our first Lok Sabha was formed in 1952. And the conflict was between the article number 16 which if you remember it is the right to public offices, and article number 46 which we have just studied. So article number 46, it says no citizens on grounds only of religion, race and caste residents be ineligible for or discriminated with respect to the employment under the office of the state. Okay, so it prohibits any form of discrimination. For article number 46, on the other hand, it says that the state shall promote with special care the educational and economic interests of the weaker sections of the society. So there is a conflict. And Supreme Court held that Article 37 expressly says that directive principles are not enforceable by the court. And Supreme Court mandated that the chapter on the fundamental rights in the Constitution is sacrosanct and the directive principles have to conform and run subsidiary to the chapter on fundamental rights. So clearly, fundamental rights were given superiority over the directive principles. And this particular judgment that fundamental rights are superior to the directive principles continued for a decade and a half. And various other cases like Qureshi versus State of Bihar, Sajjan Singh versus State of Rajasthan, court confirmed that particular stand. Then we see Golaknath case, and in this case for the first time a bench of 11 justices of the Supreme Court was formed. Okay, so very important case. The court in this case held down that fundamental rights cannot be abridged or diluted to implement the directive principle. This we have studied when we were studying the article number 13 also. And this government reacted to this particular decision of the Supreme Court, and they amended the article number 13 and 368, and which said that law doesn't include Constitutional Amendment Act, and government can amend any part of the Constitution. If you remember the article number 13, we discussed that. And then came the historic case of Keshwanand Bharati, and in Keshwanand Bharati case, Supreme Court ruled that the Parliament could amend any and every part of the Constitution, including fundamental rights, but it cannot destroy the basic structure. This doctrine of this basic structure came forward in the Keshwanand Bharati case, which we have seen. Now, to nullify the Keshwanand Bharati case, 42nd Amendment Act further amended Article 31C, and no law giving effect to the policy on the ground of implemented directive principles under 39B and C will be declared void under the fundamental rights under Article number 14 and 9. This all we have already studied in fundamental rights. And then came a Mindervilla Mills case, and which is a very significant decision in regard to the harmony between the fundamental rights and dietary principle state policy. In this, what happened actually, Parliament by 42nd Amendment Act further widened the scope of fundamental rights. We have studied that. But in this particular case, Supreme Court struck these provisions and on the ground that it changed the basic structure of the Constitution, and Supreme Court held that the Constitution exists on the balance of Part 3 and 4, and giving absolute primacy to one over other will disturb the harmony of the Constitution. So this was the decision in Minnesota case, and from then courts looks to both fundamental rights and dietary principle state policy before giving any judgment. So from there onwards, this particular case happened in 1980. We see that a court has been of the view that fundamental rights and dietary principle of state policy are complementary to each other, and there is no need to sacrifice one for the sake of the other. Okay, so this is the whole conflict between the dietary principle of state policy and fundamental rights. This is, I think, the second time fundamental rights also we discussed the same thing when we were studying the Article 13 and Article 31C. Now, the next part in Constitution are the dietary principle of state policy. It is the fundamental duties, and in 1976, by 42nd Constitutional Amendment Act, this new part, Part 4A, was included into the Constitution, named as fundamental duties, and this was 51A. Fundamental duties are under 51A, a very common question which is asked in state services. And if you can take help of mnemonics as much as you can, because dietary principles, fundamental rights, fundamental duties, these are the important articles which you have to remember by the numbers, by the digits, by the article numbers also. Let us start with fundamental duties. These duties were based on the recommendation of Sardar Swan Singh Committee, which was formed in 1976. And that time 10 fundamental duties were added under the Part 4A, and one more fundamental duty was added in 2002. Let us read it now. Fundamental duties are novel features of Indian Constitution. Originally, Indian Constitution did not contain these duties, and the 42nd Constitution Amendment Act 1976 incorporated 10 fundamental duties in Article 51A of the Constitution of India. 86th Constitution Amendment Act 2002. This is also a very important Constitution Amendment Act, which also included the right to education under fundamental right, has added one more fundamental duty in Article 51A of the Constitution of India. As a result, presently we have 11 fundamental duties for the citizens of India. So what are the 11 fundamental duties? First is to abide by the Constitution and respect the national flag and national anthem. Straightforward. To cherish and follow the noble ideals which inspired our national struggle for freedom. To upholding the struggle which our national heroes they did during national struggle for freedom. To uphold and protect the sovereignty, unity and integrity of India. To defend the country and render national services when called upon to do so. To promote harmony, the spirit of common brotherhood amongst all people of India, transcending religions, linguistic and regional or sectional diversities, and to renounce practices derogatory to the dignity of women. So fundamental duty which talks about the dignity of women, it is E. 51A E. Subpart E. Okay. To value and preserve the rich heritage of our composite culture, to protect and improve natural environment like forests, lakes, rivers and wildlife, and to have compassion for the living creatures. So again, another article which talks about the environment in Indian Constitution, it is under fundamental duty G. These things we have covered in the mnemonics as well. So that is how you have to remember these things. To develop scientific temper, humanism and a spirit of inquiry and reform. So it talks about the development of scientific temper and coming out of the age-old customs of black magic and other things. To safeguard public property and to abjure violence. to strive towards excellence in all spheres of individuals and collective activities so that the nation constantly rise to higher levels of endeavor and achievements. So all theory. This particular was added in 2002. We have seen 86 Constitution Amendment Act to provide opportunities for education by parent, the guardian, to his child or a ward between the age of 6 to 14 years as the case may be. Okay, so it has added directive principle of state policy, article number 45. It gives directives to the state, and also they are adding as a fundamental duty for the parents to give proper education for their children in the age group of 6 to 14. An analysis of the above duties reveals that they are applicable only to the citizen and not to the aliens. And it is expected that the citizens of India, while enjoying fundamental rights, should also perform these duties. Although there is no provision in the Constitution for direct enforcement of any of the duties, so they are not enforceable they are not justifiable, they are not enforceable by the courts. Yet the courts are guided by these duties while interpreting various laws. Okay, and these duties have sensitivity as these are included in directive principle of state policy. They are a part of directive principle of state policy. Okay, so these what all things you need to remember about fundamental duties. Not very difficult. Go through one of the textbook also to get more theory, to get more language of fundamental duties. Otherwise, conceptually, there is nothing much to understand in this. There is one more Verma committee. It was formed in 1999 to give its observations about the fundamental duties. It suggested certain fundamental duties to be added, but nothing got added. And this committee also identified the existence of certain legal provisions which are already present in the nation for the implementation of certain fundamental duties, like we have Prevention of Insults to National Honor Act 1971, actually, which prohibits a person for the disrespect toward the national flag and national anthem, like this. So they have identified certain legal provisions for the implementation of these fundamental duties. Now let us go to the election of president. Next lecture we will start with the first article which deals with the union and the executives, and we'll start with the president. But this class, let us briefly discuss about the election of president. It's a bit complicated process, need to explore, and often difficult for the students to comprehend and understand directly from the constitution. Article 54 and Article 55, it talks about the election of the president. Article 54, it says that shall be elected by electoral college consisting of elected members of both houses of parliament and elected members of legislative assemblies of state. And this state also includes the legislative assemblies of National Capital Territory of Delhi and Union Territory of Pondicherry. And second, it talks about the manner of election of president. But let us first start stage by stage. There are certain parts which, if we follow, it is easy to understand the election of president. The first is, it is a electoral college consisting of first MPs of Lok Sabha and Rajya Sabha. Important thing is only elected. So no nominated members are allowed to participate in the election of president. No nominated person. The second are the MLAs of legislative assemblies. So again, only elected, no nominated person, and legislative councils doesn't take part in the election of president, and no nominated, only elected persons. This also includes Delhi and Union Territory of Pondicherry. Okay, so this is the first part of election of president. Let us see. Second thing is, article number 55 says the value of one MLA vote. Value of one MLA vote. It talks about the proportional representation and single transferable vote. So we'll try to understand actually how election takes place. So to calculate the value of one MLA vote, what they do is they take the population of state, the total population of state, divided by number of seats in legislative assembly multiplied by 1 by 1000. Okay, let's take an example now. Let's take an example of Maharashtra. So Maharashtra, the population is approximately 5 crores. Exactly it is this much, and number of seats are 288. So if we calculate this, you calculate it, it comes out to be 175042. And if we divide by 1000, it gives me 175. So this becomes the value of one vote of MLA in Maharashtra Legislative Assembly. Okay, now same thing we calculate for all the states. Now what we do is, total value for the Maharashtra Legislative Assembly, it will be 175 into 288. So this will be the total value of Maharashtra Legislative Assembly. Now third part is, this was the value of one MLA vote. Second is value of one MP vote. In this case, what we do, like we have done for Maharashtra, 175 into 288. This gives me the total value of the votes of Maharashtra. This thing I'll do for all the states, and I add them. And then I divide by the total seats in Rajya Sabha and Lok Sabha for that year. Again, divided by 1000. So it gives me, for 2012 elections, this value came out to be 708. Okay, so this is the value of one MLA vote, and now this is the value of one MP, Member of Parliament vote. And this population, it is based on the status of census of 1971, which is there in the constitution, mentioned in the constitution. Like census has to be taken from 1971. Now comes the concept of preference vote. The fourth part, the preference vote. Now in this, suppose there are 4 candidates for the presidency. First one is Ram. Second one, let us say Shyam. Third one, Ali. And fourth one, Peter. So these are the 4 candidates. Okay, and this ballot is given to all the people who are participating in the election of the president, and they give the preference. Like suppose 2000 people gave first preference to Ram. Okay, 1500 people gave first preference to Shyam, 500 people gave first preference to Ali, and 400 people gave to Peter. Similarly, they give second preference and third preference also, and fourth preference. So this is the preference vote. They give preference to each person. Now this is the stage 1, where what happened is, Ram received 2000 first preference, Shyam, Ali and Peter. These are the first preferences received by these people. Now to win the election, they have to secure minimum of total number of valid votes. If you count, it becomes 4400 divided by 2 plus 1. So 2201. These many votes has to be secured by the person to be declared as a president. Okay, so preference vote, these are the candidates. They received, this is the first stage, stage 1, and these are the first preference votes. Now in this we can see no one is securing these many votes. Now what will happen is, the last one, Peter, will be struck off. Okay, and his 400 votes, we will see the second preference. So the ballots which were having first preference as Peter, we have striked out Peter because he is last in this first preference, and then we will see how many second preferences we have received. for the other candidates under the ballots of Peter. So second stage is second preference of Peter ballots. Now suppose Ali has 200, Sham has 100 and Ram has 100. So out of 400 ballots of Peter, Ali has 200 as second preference, Sham has 100 at second preference and Ram has 100 at second preference, and we add it now. So total Ram becomes 2200, sorry, Ram becomes 2100, Ali becomes, let us see, Sham becomes 1600 and Ali becomes 700. Okay. Now what happens is same thing what we did in stage 1. Ali will be striked off. He is last in the race. And Ali's ballot, we will see the third preference. So third stage is third preference of Ali ballots. Now how many Alis have 700? So out of 700, Sham got 620 as third preference. Ram got only 80 as third preference under the Ali ballots now. Okay. Now if we add it to the total, so Ram is having 2180 votes and Sham is having 1600 plus 620, that is 2220, and total votes how many is required? 2201. So in this case Sham won the election and Sham became president. Initially in the first preference though Ram was way ahead of Sham, but finally Sham won. Okay, so this is the concept of preference vote and proportional representation in matter of election of president, a very important and conceptual thing to understand. You again make your own fresh sheet, you try to do these calculation, and once you will understand it, you'll never be able to forget it. So here we will finish this particular lecture, and next time we are going to start with the President of India, and we'll finish the Vice President of India as well, and then we will see the Governor of a state. So thanks for tuning in.